Hey everybody, News Now Wyoming here, bringing you another episode. This time is part 3 of the Auditors versus Salvaggio. And this is there in Leon Valley. A lot has happened inside the courtroom and outside the courtroom since the last video I did. Salvaggio and team kept extending the time to respond, lying to the, in my opinion, in my own opinion, so this is not based off of anything besides the record here, lying to say that there's federal charges coming. There never were, and all state charges have been dropped against everybody. There are no more pending charges. And then they kept trying to extend the time, and finally the court said, no, you're being stupid. Let's just get this over with. And then as soon as it was opened back up, all the auditors filed a amended complaint by and adding on the prosecutor to the case, prosecutors for their conduct. Now I do want to say, unless the prosecutors are acting in a investigative manner, which none of the complaints show that they have prosecutorial immunity. I don't agree with this standard, but it is 100% immunity against all charges, just like judges do. As long as they don't act in an investigative way, they cannot be sued in any capacity against them. Okay, so I do want to make sure that is clear. It's not really proven that they went beyond the pale there and went into the investigative side. And even if they went to the investigative side, they would have to violate a clearly established right. Which, they do not have to meet the same standard that the police officers do. Alright, so let's get right into some of these responses here. So let me open up Adobe here, and let's first look at Bexar County's motion to dismiss. Now come defendants Lico LaHood and Joe Gonzalez, who are both named in this action in their official capacities as the current and former Bexar County Criminal District Attorney. Plaintiffs initiated this litigation by filing their complaint against the amended complaint in July 2018, and following a nearly 2-year stay of these proceedings, they filed a second amended complaint naming Bexar County as a defendant for the first time. Plaintiffs are a group of 15 protesters who demonstrated outside Leon Valley Police Department on June 14th, 18th, and 23rd, and alleged that they were subsequently subjected to unreasonable searches and seizures by the Leon Valley Police Department and its police chief and officers. So they're going to go against some of their allegations here. We're not really going to talk about that because that's not germane to this. Because this is the respondents. Only these two. Only these two defendants. Okay, so this motion comes just from these two defendants, who are the district attorney. So we're going to try to figure out exactly what they sets forth their claim in 15 counts. Defendants LaHood and Gonzalez enacted unconstitutional policies and procedures to maliciously and frivolously prosecute Mr. Brown, to retaliate him for engaging in constitutionally protected conduct. Referring to all defendants, plaintiff alleged that they procured a prosecution against plaintiff, knowing he is innocent of the charged crime, initiated the charges to somehow justify their own unlawful actions, and initiated and procured the proceeding with their false statements and charges. Lacked probable cause to initiate the criminal proceeding, and the proceeding was terminated in plaintiff's favor when the charges were dismissed. So they continue to assert the same malicious prosecution, right? So the district attorneys used malicious prosecution. Malicious prosecution claims again. Sufficiency of a pleading to a state claim upon which relief can be granted under federal is evaluated in a two-step process outlined by the Supreme Court in Bell Atlantic versus Twombly and Ashcroft. First, the court must identify the complaint's factual allegations, which are assumed to be true, and distinguish them from any conclusory statements that are not entitled to the assumption of truth. Second, the court must assess whether the assumed as true factual allegations set forth in a plausible claim to relief. This is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense to determine whether the well-pleaded facts permit the court to infer more than the mere possibility of misconduct. Ultimately, the claim is subject to dismissal if it lacks factual content that the court allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Taken together, the allegations set forth against Bexar County are that the DA initiated criminal proceedings against them. Plaintiffs allege that BCDA prosecuted these individuals after the officials had subjected them to unreasonable searches and seizures, and did so in reliance on partially false information presented to them by Leon Valley stupid police. Plaintiffs also assert a conclusion not supported by any facts pleaded in the second amended complaint that Bexar County prosecutors acted without an improper motive to shield Leon Valley from liability for the constitutional violations that plaintiffs allege, and to retaliate against plaintiffs for exercising their rights to free speech. Plaintiffs allege that these prosecutions violated their constitutional rights and are therefore actionable. Violated their constitutional rights and are therefore actionable under Section 1983 because they were motivated by this improper purpose, and because the prosecutions involved the possibility of jail time and criminal records, because multiple prosecutors were assigned to the cases, and because prosecutors discussed the possibility of plea agreements to the plaintiffs. For several reasons, these allegations are insufficient to state any viable claim against Bexar County or the DA's office. The plaintiffs' claim against BCDA are squarely precluded by prosecutorial immunity, under which a prosecutor is absolutely immune when she acts in her role as an advocate for the state by initiating and pursuing prosecution. Again, I don't agree with the standard, you guys. I want to make sure that's clear, because you guys are going to be cursing at me in the comments. I know that. I don't agree with this standard. This is a standard created by the Supreme Court, not by law. And I don't agree with those because they are not policy makers. They are finders of fact and finders of what's in the Constitution. And this is not in the law or the Constitution. So I don't agree with this standard. But I agree that this standard precludes this lawsuit from taking place. So, because they're not saying that the prosecutors acted as investigators. They're not saying that they crossed that line. Plaintiffs have not pleaded facts that could show Bexar County's 1983 liability as a municipal entity, since they have not pleaded facts sufficient to show any policy or practice of Bexar County, much less one that caused constitutional deprivations they allege. And again, I will agree with this. I don't think Bexar County falls under Monell. I think the city could easily fall under Monell, but I don't think the county does. Oh, wait, and here they're going, even setting aside immunity on Monell issues, they have failed to plead facts that could show any underlying constitutional violation by BCDA. This is especially true since the Fifth Circuit has long held and recently affirmed that malicious prosecution and abuses of process are not viable theories of constitutional injury, and therefore are insufficient basis for a viable 1983 claim. So this is stating that under this precedent here in Morgan, that even if it was malicious prosecution, that doesn't actually violate your constitutional rights. That's a stupid argument. God, I hate this argument. I do. I despise this argument. If a so let's pretend for a second that I am dating a prosecutor's daughter, or I'm married to a prosecutor's daughter, and cheat on her. Let's go there. I cheat on her. And then it is alleged that a cop pulls me over for driving with a broken blinker. Okay? My blinker's broken. Let's just pretend that. And then the prosecutor takes me and the prosecutor himself takes me to court and tries to get the max penalty and tries to add charges on because I told the cop to F off and all kinds of stuff. So he adds charges beyond what the officer charged me with, which was failure to have a blinker fluid. I don't know. I don't know what the Wyoming statute is on that. Okay, I would have to look that up. Not important for this. But he adds charges on as is his right as a prosecutor. He can examine the evidence and say, no, he's also guilty of these crimes here. And then he prosecutes me. I cannot sue that prosecutor for misconduct, according to this standard here. Again, I don't agree with this standard, but I agree that according to the standard that is currently what the courts use, that everything that they are saying in this motion to dismiss is true against the prosecutors. And yes, I hate every bit of that. I hate admitting that. And no, I am not married, and I'm certainly not married to the prosecutor's daughter. Okay? But I want to make sure that it's clear that no, I don't agree with it, but that is the law. Or that's not the law. That is the interpretation of the law as the Supreme Court has held. It's stupid. I don't like it, but there it is. Any of these defects would be sufficient to require the dismissal of plaintiff's claims against Bexar County. For all these reasons, the motion to dismiss should be granted, and the claims against Bexar County should be dismissed in their entirety under Federal Rule Civil Procedure 12b-6. So here again, they're going to reclaim that these are barred by prosecutorial and 11th Amendment immunity. I'm going to agree with their statements here as much as I hate that. They have not pleaded facts that could show a policy or practice of Bexar County. There is no written policy that says they will back up the Leon Valley Police Department. And even if so, they're immune anyway, so it doesn't matter. Alright, not pleaded facts. Okay, so yep, I will agree with this. Plaintiffs have not pleaded facts that could show any underlying constitutional violation by BCDA. And so they are saying that the case against them should be dismissed. This is not the police response. So let's look at this other pleading. So this, so this is just another reply to support their motion to dismiss. I apologize, I thought I downloaded a different one. So let me see if I can. And that's right. Anytime I would actually, and I've been having this issue with Pacer here lately. Anytime I'm trying to download one of these reports I've never downloaded before, it's telling me I've already done it. So it charges me for the 14 pages of this response, but I can't actually ever get the PDF version. When I try to right click it and say save as, normally it shows me a PDF and it's showing me the HTML document that says, oh, we've already charged you, you've already seen this, so we can't show it to you again. So that's why I can't actually do a response video on the police, because I can't actually read the police response. Now somebody can, I'm sure somebody out there already has a copy of this, the police response. It would be, let's go to the docket here. So it would be docket number 94 here, Oh no, sorry, not 94. It would be docket number 92 on this case. First amended answer to 87 amended complaint and second amended complaint. So that's the one I'm trying to access, and Pacer will not give me access to it. So if somebody knows somebody who already has this out there in the public domain and could send me a link, I would greatly appreciate it. I would love to read what how the officers are responding, and I'd like to do a reaction video to that. So other than that, you guys, I'm going to go ahead and end this video here. Thank you for joining me. And just because I agree with the motion to dismiss in their legal arguments does not mean I agree with what those legal arguments are, okay? Prosecutors should not be immune. That is not in the law. That is not in the Constitution. However, they are. That is the way that the law is currently interpreted by all courts, and I don't see that changing any time in the next 20 to 30 years. I don't. So they've had lots of times where they could show that the prosecutor was extremely horrible. Okay, lying and knowingly adding in witnesses that were lying and excluding evidence, and this is all one prosecutor, and they still had prosecutorial immunity against civil liability. They were prosecuted and they were found guilty and they were sentenced to prison, but they were still not able to be sued because of prosecutorial immunity. It's absolute immunity, which cannot be broken under any circumstances as long as they did not act as the investigator. It's stupid. Okay, it's horrible. God, and I wish it would go away. I do. You can look up all kinds of cases. Look at prosecutorial immunity and all the case law about it. And it cannot be broken civilly. It can be broken criminally because it does not cover criminal conduct or criminal charges. But it does protect them from being sued for their misconduct. And yeah, no, so we'll go ahead and end this video here with that caveat that I agree with this motion to dismiss solely on the legal grounds that it brings, not because I support those legal grounds. Thank you, and have a great day.